Please subscribe the channel and hit the bell icon for the future uploads.
Hello everyone. In this part of the video, we are going to see the provisions relating to restitution of conjugal rights in Parsi law. So, on this topic, what will be the questions asked in the question paper? It will be discuss the provisions for restitution of conjugal rights under Parsi law, or what are the provisions relating to restitution of conjugal rights under Parsi law. Questions asked in the exam. 1. What is the provision for restitution of conjugal rights in Parsi law? Second, discuss the provision for restitution of conjugal rights under Parsi law. This question will be asked only for 4 marks or even lesser. So this is very short. It can be written in 2.5 pages. So it will be a short note. But even if it is a short note, we should write synopsis and we should write by points so that it gets easier. In the synopsis, we should write introduction first. Second of all, we should discuss the concept directly, and third, conclusion. Even if you write these 3 points, it is sufficient. But you can add a 4th point also. I will discuss in the later part of the video. As far as firstly introduction, we can say that the basis of any matrimonial life is cohabitation. So whenever parties are residing with each other, that is the very much object of any marriage for that matter. And if that object is not getting fulfilled, the law should provide some kind of remedy to the other, and that's when the birth of restitution of conjugal rights came into existence. Now let's see what the restitution of conjugal rights actually means. Restitution and conjugal rights are 2 different words. Restitution means to reinstate, and conjugal rights means matrimonial relationship to live together, that is the right of cohabitation. So to reinstate right of cohabitation, we call it restitution of conjugal rights. Now, what is restitution of conjugal rights? We have seen. What is the provision under the Act? The Act very much states that when one spouse, without any cause or reasonable ground, deserts or removes from the cohabitation or the company or comfort of the other. So this application can be filed by both husband as well as wife. So if a husband is filing and the wife has deserted such husband without any reasonable cause or excuse, or is living separately from that person, then that husband can file a petition for restitution of conjugal rights under Parsi law, and it can be granted by the court if it is satisfied that there really is no ground for that wife to live separately from such husband. Here both husband as well as wife can initiate the proceedings under restitution of conjugal rights. What is the peculiarity here? Usually we have seen that the burden of proof lies on the person who alleges. So Hindu law specifically has a provision that the respondent should prove the case. Here there is no such provision. As far as burden of proof, still in this case lies actually upon the petitioner, since he is stating, he should state that the respondent has left the matrimonial home without reasonable cause or excuse, and again the burden also is upon the respondent to prove that yes, there is a reasonable cause or excuse to live separately from the person. So after writing this, that what is actually the restitution of conjugal rights, there is another peculiarity of this concept. If the decree of restitution of conjugal rights is passed by the court under section 36 of Parsi Marriage and Divorce Act, and still there is no cohabitation between the parties, it creates additional ground for divorce. So there is a special section in the Parsi law which states that additional ground is created if a decree of restitution of conjugal rights is passed and the party has not come to reside with the spouse even after passing of such decree. So this is a peculiarity, and if you write it, definitely you will get a better mark. See, while writing a restitution of conjugal rights, many students will not even touch this topic, that if the decree is granted and the party does not come to reside, what is the effect of it? And if you write it, it will give a upper hand in your answer, and out of 4, might be you will get 3 out of 4 if you write this peculiarity also. Section 36, restitution of conjugal rights. It can be filed by either husband or wife. when one spouse has, without any reasonable cause or excuse, has deserted or ceased cohabiting with the other. So after writing the introduction part, restitution of conjugal rights part, and then not following the decree, we should write the conclusion part as well. To conclude, we can say, to save the matrimony, it is very much important that the husband and wife should stay together, and to safeguard this interest, Section 36 was added in Parsi Marriage and Divorce Act. Thereby, a spouse can come to the court and say that, see, my spouse has left me without any reasonable cause or excuse, and please ask him to come back to me. So to reinstate the right of conjugal bliss, this section has been inserted. This will be the conclusion part, and if you write all this, even the peculiarity, I think you will get 3 out of 4. The same video in Marathi language is also uploaded on YouTube, link of which is given in the description box. Please follow the same.
If you have liked the video, please give a thumbs up. Video on various topics are going to be uploaded on YouTube. Please subscribe the channel and hit the bell icon for the future uploads. Thank you.